This video provides a concise summary of everything that is addressed by utilizing the currency market cap. In addition, I would appreciate it if you would consider funding my channel so that I may continue to keep you informed about XRP and other cryptocurrencies. The decision that Torres made regarding the sale of XRP on the secondary market has been called into question by an executive authority body. Each of the two companies, Coinbase and the United States Securities and Exchange Commission (SEC), went through major changes as a direct result of the decisions that Judge Catherine Fire made in the context of the dispute that occurred between the two organizations. It has been said by John Reed Stark, who once served as the Chief of Enforcement for the Securities and Exchange Commission, that the SEC has achieved some level of success. According to John Reed Stark, who formerly served as the chairman of the SEC Office of Internet Enforcement, the most significant setback for Coinbase and Ripple was the fact that Judge Fila completely reversed Judge Torres' reasoning in the Ripple case. This was the most significant setback for both companies. When programmatic customers were successful in passing the Ho test in programmatic sales, they discovered that they were in the same position as buyers in the secondary market. They were unaware of who they were paying or what they were paying for. In spite of the fact that Judge Torres has made the decision not to investigate transactions that take place on the secondary market, John Deaton is in support of the Torres doctrine. An example of a transaction that takes place on the secondary market is Coinbase versus the SEC. Which choice is open to you? Judge Fala found that Coinbase engaged in the activity of unregistered securities staking. This was demonstrated throughout the proceedings. In light of the fact that the case is now being advanced, Coinbase will make use of its legal grounds. The lawsuit will proceed to the discovery phase as a consequence of the decision made by the court, and it will ultimately be submitted to a jury for trial. The Securities and Exchange Commission (SEC) has made a number of charges, one of which is the assertion that the company acts as a broker without a license. The court, however, did not take into consideration Coinbase's status as an unregistered wallet brokerage service. This decision was delivered by the court as a consequence of a lawsuit filed by the SEC. Although certain coins met the requirements of investment contracts, the decision came to the opinion that Coinbase was not a brokerage. This was the result reached by the decision. An examination concerning the pricing of waves of XRP is currently being conducted by attorney Fred Risley in the case of Ripple. Concerns have been raised about the company's alleged practice of providing discounts to institutions, which has led to criticism. Within the context of the ongoing legal battle with the Securities and Exchange Commission (SEC), which is pursuing a fine of $2 billion, the response that Ripple provides is of the utmost importance. Ripple is currently dealing with a dilemma over XRP as a consequence of claims of discounted institutional sales, which raises doubts regarding the transparency of the cryptocurrency market. In the middle of a lawsuit brought by the Securities and Exchange Commission (SEC), attorney Fred Rispoli is conducting an inquiry into the unusual pricing of Ripple's XRP. An attorney by the name of Fred Rispoli provided information that was constructive with regard to the expenses. An extra layer of uncertainty has been added to the situation, which has further exacerbated the disagreement about XRP. Allegations of discounted institutional sales have been adding to the mystery. Would those who invested in XRP be able to survive if they were compelled to take the blow? At this point, the outcome will be determined by the next step that Ripple makes. It has been reported that Ripple engages in the practice of providing discounts on XRP to institutional customers. This practice has been criticized. It is possible to trace the origin of the problem back to study on risk bullying. There is a possibility that this strategy was an element that contributed to the unsatisfactory market pricing of XRP. According to the Securities and Exchange Commission (SEC), a pricing differential that was adverse to regular investors who purchased XRP at higher prices was caused by preferential treatment. This discrepancy was caused by a price difference. It has been proposed by the SEC that Ripple be punished with a fine of $2 billion. In accordance with the regulatory agency, Ripple's sales mechanism is in violation of securitization guidelines and does not provide sufficient transparency, both of which have a negative impact on investors. A clear indication of the seriousness of the issue is provided by this action. It has been claimed by Rizzoli that providing discounts to institutions for purchases could potentially exacerbate market volatility, particularly during times when prices are increasing. When prices are higher, it is possible for institutions to sell vast quantities of things. This is especially true during times of price increases. Ripple is currently considering the motion that was submitted by the SEC, and the business is currently working on crafting its response towards the motion. Regular investors, on the other hand, who provide exit liquidity for institutional players can find themselves in a disadvantageous position. It is predicted that the conclusion of the court case will have an effect on the price of XRP, despite the fact that none of the details of the case are known. Ripple and its investors are exposed to the possibility of massive repercussions, despite the fact that the dynamics of the Bitcoin market and the compliance with regulatory requirements are enormous. The next step that Ripple needs to do in order to solve the problem with the pricing and win back the confidence of investors in XRP transactions is to take the next most appropriate action. This is coming about as a result of the fact that Ripple is currently being examined and is facing legal difficulties. What is the point at which the conflict between the Securities and Exchange Commission (SEC) and XRP, as well as the Wolf of Wall Street, James Murphy, will be resolved? Regarding the cryptocurrency firm Ripple, Scott Milker examines the damages theory that was suggested by the Securities and Exchange Commission. He also calls attention to the fortunate conditions that surround the cryptocurrency company. A judicial precedent that requires the Securities and Exchange Commission (SEC) to identify victims who have lost money in order to demonstrate illegal behavior is the subject of his investigation. In addition to this, he explores the various ways in which the SEC damage theory could be read in relation to important concerns. In reaction to the decision that was handed down by the Court of Appeals for the Second Circuit, he brings up this particular argument. The position taken by the SEC with regard to losses is highlighted by Melker, who brings to light a significant inaccuracy. The Securities and Exchange Commission (SEC) contends that certain buyers got XRP at prices that were lower than they had been before. All XRP clients who have lost money are unable to be identified by this system, which is the reason for this situation. It is important to note that this claim goes beyond the sphere of monetary damage because it does not specify specific companies that have experienced financial losses. This is the predicament that has arisen as a result of the Securities and Exchange Commission's failure to identify specific victims who have lost money. The argument that they have is not as strong as the one that they have. The notion of discouragement, which seeks to restore illicit income to those who have been damaged, is unsuccessful in instances where there are no victims who can be recognized independently. This concept was developed with the intention of restoring people who have been hurt. Due to the fact that it is dependent on customers who have been prevented from making purchases and have caused financial hardship as a result of this, the CCC's claim for $200 million in doll interest is uncertain as a result of this. That's all for now. Remember to support us by subscribing to our YouTube channel, like and share this video to your friends. Turn on your notification to receive more updates in the future.